Our main panelist is Advocate Saroha, supported by Advocate Toofan, Mr. Malik, and Mr. Hooda. Today, we'll be discussing code on industrial relations, wages, social security, and occupational health and safety, followed by Q&A session. Mr. Saroha is a graduate in law with specialization in labor laws and master's in social science with specialization in industrial relations and personal management. Advocate Saroha has a career track record of 50 years in industrial relations, human resources, and labor laws. Initially, he worked in good Indian corporates for 14 years, including Apollo Tires, and since 1982, he has been advising industry in these areas and representing in industrial tribunals, labor, and high courts. His thrust in consultancy is to implement labor laws, settlement in spirit, resolving all the issues through mutual negotiations, conciliation, and not adjudication. He has been resourceful in resolving difficult IA issues with proactive and positive approach. He has good team of well-experienced advocates to assist him. Advocate Saroha is also associated in advisory capacity on labor laws and industrial relations with Gurgaon Industrial Association, Faridabad Industrial Association, Haryana Chamber of Commerce, and Confederation of Indian Industry. He also has been president of Haryana Labor Law Practitioners Association. Moving forward, I would like to now I would request Advocate Saroha to throw some light on the Industrial Relation Code. Over to him.
Hello friends, good afternoon to all of you. I am J.S. Saroha. I have been continuously in touch with you with regard to the industrial relations and labor law matters. I will be taking up Industrial Relations Code, which consists of Industrial Disputes Act 1947, Trade Union Act 26, Industrial Employment Standing Orders Act 1946. Actually, Government of India has been preaching for quite some time that they will be bringing out revolutionary labor reforms which will boost the industry and will be very beneficial to the employees. That is besides the question. In any case, there has been simplification and codification of all 29 acts into 4 codes. So old laws have been repealed and now entire industrial law is in 4 codes. The code on industrial relations is very important from industrial peace point of view. Industrial relations can be maintained well if these acts are well complied with. Now, I will take up Industrial Relations Code, preliminary Chapter 1. Appropriate government. Central government is appropriate government. For Government of India, PSUs, it has to have 50% plus holding, but even if the holding is reduced to less than 50%, appropriate government will still remain the central government. Railways, metro railways, telecommunications, banking also have been added in this. Appropriate government for state public undertakings. State undertakings are to be guided by the state government. Therefore, their management and the appropriate government in their case is state government. Appropriate government for certain specified industries, certain controlled industries which are governed by Government of India. So appropriate government in the controlled industries is this central government. Employee. Definition of employee has been very exhaustive. It takes into consideration workmen from unskilled up to managerial level, except apprentices under Apprentices Act. Employer. Definition of employer has been completely modified, and it means head of the department of the central or state government, occupier of the factory, manager of the factory under clause F of section 1 of 7 of Factories Act 1948, the person who has authority or has ultimate control over the affairs of the establishment, then contractor and legal representative of the deceased employer. Here, I would say that for Factories Act being occupier, director has to be one of the occupiers. Fixed term employment. The fixed term employment existed in Industrial Employment Standing Orders Act and was incorporated 2 years back, but with a very small notion. In the code, fixed term employment has been elaborated, well defined. It means that all the benefits available to permanent worker will be payable to the fixed term employee. Besides, fixed term employee will be getting gratuity only on completion of 1 year service. Industry means any systematic activity with the cooperation of employer and workmen to satisfy the human needs. In the definition, substantially engaged in charitable, social, philanthropic services and certain functions have been excluded. Industrial establishment or undertaking, any unit or such establishment which part of the same venture can be severable, and that part which we want to say severable from the main plant means by the closure of that plant, there is no effect on the activities or production of the main plant. Recently, we had obtained permission for closure of a department of factories like Rico Auto Industries. There, some parts were severable, and therefore they have been treated as separate unit. Strike, it includes if concertedly 50% of the workmen resort to casual leave. Lockout means the temporary closing of place of business or suspension of work of operations. Strike is weapon in the hands of workers. Lockout is weapon in the hands of employers. Lockout consequent upon illegal strike is justified and legal. But lockout is a situation which is created to be attributable to the conduct of the workers. Such situations like strike, gherav, sit-in strike, obstruction in working, etc. Trade union dispute has been added in these disputes. Trade unions arising to unions or between work members of the trade union. Wages means all remuneration, whether by way of salary or allowances, expressed in terms of money, which include basic wage, DNS allowance, and retaining allowance. Then in the section from A to I, subsection A to I, are the components which, if put together, amount to more than 50%, then that amount will be treated as wages. But worker now includes supervisory capacity earning wages up to 18,000 rupees. But workers' definition has been in dispute because worker is a very wide subject, wide term so far as the industrial law is concerned. Managements have been calling some of the staff members as worker, whereas where there is an element of supervision, primary element of supervisor is out of the purview of workman, otherwise he will remain as a workman. Don't include managerial, administrative, apprentices, etc. Employee includes increased worker. Employee includes working journalists, sales, promotion, newspaper employees as defined. Code defines discharge, dismissal, retrenchment, or otherwise termination of service of a workman. And then individual workman can file a case for reinstatement for resolving his dispute. If demand notice is filed and within 45 days there is no settlement, then the workman can approach the industrial tribunal directly and the dispute will be taken as a reference and tried as a reference by the tribunal. Grievance Redressal Committee members have been increased from 6 to 10. Establishment employing 20 or more persons, workers, it will be applicable. Redressal Committee will consist workers as well as employer, equal number. Women representation has to be proportionate. There will be chairman of the committee, which will be rotational. Once it will be for the management side, next time it will be by the workman side. Sole negotiating union, where the union having 51% of the workers, it will be sole negotiating union. When there is no union which comprises of 51% of the workmen, there will be negotiating council where there is a multiplicity of unions. Then the 20% of the workers number will be one representative for each 20%. Recognition of union is by 3 to 5 years. If there is a settlement between negotiating or council, then it will amount to a settlement under the Act. Facilities have to be provided, negotiating union, which will be decided and prescribed by state government. Registration of union will not be registered, union will not be registered if 10% or 100 number of workers are not there. That is the limit for registration. Appeal against registration cancellation will lie before industrial tribunal. office bearers of unorganized sector, where there is unregistered, registered union and unorganized sector, 50% of the office bearers will be workers really engaged or employed in that industry, and workers who have been retired or who have been retrenched will not be counted as outsiders. Standing orders. The threshold limit has been raised to 300 plus more. It can be reduced or increased by the appropriate government. In the state of Haryana, previously this threshold limit for standing orders were 100, but in Haryana it was 50. Employers required to prepare draft standing orders within 6 months of the commencement of the Act code. For consultation is required even when the draft to be finalized. Consultation with union or negotiating agent for making draft of standing orders. Previously, it was the employer responsibility to draft standing orders and submit them for certification. Employer can adopt model standing orders and they will be deemed as certified. Certified standing orders, employer files this draft, the certifying officer sends a copy of the draft to the negotiating union or council or the workmen representatives to be chosen for standing orders to be certified. The election of such representatives is held by an officer of the Labor Department to choose 3 or 5 representatives among us the workers. Standing orders which are already there, they will continue to be certified standing orders. Appropriate government may, by notification or direct provisions of the said section of notice of change, subject to the conditions as may be specified. Industrial dispute can be voluntarily referred to arbitration by employer as well as workers. Again, workers to be represented by negotiating union or council, and where there is more than 2 arbitrators, 1 arbitrator will be appointed as umpire, and his decision in case of dispute will be final. Conciliation officer shall hold proceedings relating to industrial dispute not after 2 years. So demand notice and the dispute have to be within 2 years. Voluntary referred to the arbitration by employer as well as workmen by written agreement. Conciliation proceedings shall be deemed to have been commenced on the first date of meeting of the conciliation, and it will be deemed to have been concluded on settlement being signed by the parties. 2, when the conciliation officer records his finding that no settlement is possible and he closes the proceedings. Within 90 days, the concerned party can approach the tribunal. Notice of termination of settlement. The parties can give 60 days notice for termination of the settlement on the expiry of the settlement. No civil court other than the tribunal shall have power to entertain any suit, other proceedings in relation to disputes referred to in subsection adjudication of tribunals. Limitation of recovery of money due from employer. if the money or the claim is under settlement or award or amount payable under chapter 9 and 10, this section will be 59(1). Whereas there are other amounts payable to the workman from the employer, that section will be 59(2). These sections are from the old act, replicates of the same old 33(1), 32. 33(2) means 59 within bracket 2 section means that no new rights can be created under this recovery proceeding. Rights already adjudicated upon and the amount to be recovered from the employer can be put under this section. Publication of awards of industrial tribunal as outcome of dispute. Now, previously, the awards were sent for publication to the government, and it used to take months together for publication, and sometimes to delay the proceedings, employer would not allow the publication to happen for months together. This, to overcome this problem, this code says that award is executable within 30 days as if it is decree of land area, it's code of civil court. Interim relief, tribunal can of course grant interim relief to the workers in termination of services. Interim relief is made when prima facie it looks that the workman was not given an opportunity of being heard. So, right at the beginning itself, an application comes from the worker when he has been illegally terminated that he should be compensated by way of interim relief. Legal position in this subject is interim relief can be awarded, of course, by the tribunal, but where domestic inquiry has been conducted, the fairness of domestic inquiry is a preliminary issue, that whether the inquiry is fair and proper, and then termination of the employee. Where inquiry has been conducted by the employer, the issue of inquiry will be decided first, then only question of interim relief will come. That's why many a times employers say to us that this man has conducted himself in such a nefarious manner and his services should be terminated forthwith. Then legal reply to that question is that if domestic inquiry is held, court will see prima facie there is a case against the workman and in favor of the employer, and interim relief application will not lie. But if direct termination is there without giving opportunity of being heard to any workman, then court can start giving interim relief, and that relief will continue irrespective of the years court takes. So far, industrial tribunal has been headed by one presiding officer, but as a result of this code, now there will be two members, one from judicial side, other from administrative side. Next. Prohibition of strikes and lockouts. All establishment without giving notice. Then strike and lockout will also be illegal when conciliation proceedings are going on, when there is a reference of a dispute before tribunal, it is going on, and where there is an award against any party or there is a settlement in operation. During that period, strikes and lockouts will be illegal. Next. Prior permission of the government for closure, layoff, and retrenchment. Now, this limit has been 300. Previously, it has been ranging from 500, 100, between this. Now, if a establishment wants to close or lay off or retrenchment, then permission of the appropriate government will be required. For that, an elaborative detailed document is to be submitted by the employer giving reasons of layoff, closure, or retrenchment, and justifying what actions management has taken to avoid closure, layoff, or retrenchment. The parties will be called by the appropriate government labor commissioner state in Haryana, who will reply the questions raised by the management in the closure, layoff, and retrenchment applications. If there is a recruitment of employees, workmen within 1 year of retrenchment, he shall be given priority to the retrenched workmen. A new fund has been created under Section 83 of the Code. Employers shall contribute amount equal to 15 days wages last drawn for every retrenched worker in the fund, which shall be credited to the retrenched worker. Actually, the fund will be maintained by the government, appropriate government, but the employer has to make this contribution and then the amount will be paid to the workers. Next. Code of Industrial Relations, Social Security, punishable imprisonment up to 1 year with 1 fine. This has been compounded now up to 50% of maximum fine, 75% of maximum fine, penalties to be given to the employer in case of prosecution. Next.
With this, I would like to thank Mr. Saroha for explaining the Industrial Relation Code. Now, I would like to request Mr. Toofan Singh to take up the code on wages. Mr. Toofan Singh is a graduate in law from Faculty of Law, University of Delhi. He has a career track record of 15 years in industrial relations and labor laws. He has been advising industry in these areas and representing in industrial tribunals, labor and high courts. He has always shown proactive approach in solving industrial relation problems. His positive approach has been highly appreciated by the industry. He has been instrumental in solving difficult IR problems at Honda Motorcycle and Scooter India Private Limited, Messrs. Hero Motocorp, Yamaha India Motor Limited, GKN Driveline, TVS Motors, Rico Auto Industries, Munjal Showa Limited, India Nippon Lighting, FCC, and many more. Due to his hard work and sincere efforts and good behavior, he has been promoted to the position of associate partner with Messrs. Saroha and Associates, who have the privilege to advise most of the well-managed and progressive industries in North India. Over to Mr. Toofan Singh Kuhad.
Thanks, Sandeep, for the lovely introduction which you gave out me. So, good afternoon, all of you, all the participants. Today, I am here to discuss the Code of Wages 2019, in which the 4 statutes, that is Payment of Wages Act 1936, Minimum Wages Act 1948, Payment of Bonus Act 1965, Equal Remuneration Act 1976, has been consolidated in one code, that is Code of Wages 2019. So first of all, I would like to convey to all the participants that this Code on Wages 2019 and other 3 codes will be applicable to all the companies, industries, maybe from next year, and that is from April 2021. and this information is as per the statement given by the Ministry of Labor. So there is no hurry regarding the applicability of these 4 codes and the compliance which has to be done under these 4 codes. I would also like to inform all the participants that this PPT is made very descriptive in order to give you all participants a good subject material on these 4 codes. Now I shall be discussing the major changes which has taken place due to consolidation of 4 codes, 4 statutes into this Code of Wages 2019. This webinar will not make you a master or subject matter expert, but yes, at least after hearing us today, you will become a little more aware about the laws applicable on you due to these 4 new codes. So first of all, I am taking you all on this code chapter wise, and to start with I have chapter 1 regarding the definitions. So the first definition is the definition of employee. The definition of employee was not there before in the Equal Remuneration Act and Minimum Wages Act, and now the definition of employee will cover the Equal Remuneration Act and Minimum Wages Act both, and all the employees, whether it is the senior most in the company like a managing director also, and if the managing director is salaried, he will also be covered under this definition, irrespective of the duties and responsibilities. So now the employee or person who is performing supervisory, managerial and administrative duties has also been included in this new definition of employee. Next definition is wages. In the definition of wages, only the basic pay, that is the basic wage, the DA allowance, DA, and retaining allowance has to be included in this definition of wage. The other allowances, as mentioned in this definition from clause is A to I, has been excluded from the definition of wage. But there is a catch in this definition. If these allowances which have been mentioned from clause A to I are more than 50% of the total wages, then the amount which exceeds 50% of wages will be treated as wages. In this new code, there is no discrimination on gender basis and will include all now male, females and transgender also. Transgenders was not before in the 4 statutes. The wages will be paid similar to similar work performed by the person, whether male, female or transgender. A new transgender act has also been enforced by the central government a few months back, and the compliance of that act has to be made also. And now the transgender has also been included in these 4 new codes. Next, chapter 2 is regarding the minimum wage, in which the central government has now introduced a new concept of floor wage. Floor wage means the wages will be decided and declared by the central government on the basis of geographical region like north, south, east and west. And the minimum wages fixed by the state government will not be less than the floor wages as decided by the central government. The minimum wage will be paid to an employee on the basis of work performed by him, her or her hourly, daily and monthly basis. The minimum wages will be revised and reviewed by the government with an interval not exceeding 5 years. This 5 years was not before, and as we know that in the state of Haryana and state of Rajasthan, the minimum wages revised by the government after every 6 months, and the applicability is from 1st of January and 1st of July every year. And just to let you know all, that's a few days back only the Haryana government has revised the minimum wages from 1st of July 2020. Next is overtime wages. Overtime wages has to be twice the normal rate of wages, which was before also, and this normal wages is now will be taken as the new definition of wages, which now includes the basic pay, DA and retaining allowance. The limitation period to file a claim for in this new Code of Wages 2019, which include minimum wages, payment of bonus act, and equal remuneration act has now been increased from 6 months to 3 years. Before it was only for 6 months, and in this case, if a employee files a claim, then the burden of proof before was on the employee. Now in this new code, it has been shifted to the employer. So now the employer has to prove that the claim filed by the employee is not maintainable and the claimed amount by the employee is not payable to him. The trade union can also file this claim on behalf of the employee who is a member of this trade union. Sorry. Next chapter is regarding payment of wages. Now this payment of wages is applicable on all the employees now, irrespective of their limit or wage limit, meaning thereby the employees who are drawing salary, whether it is 10,000 or 1 lakh or 2 lakh, they all the employees are covered under this definition. So a managing director who is drawing wages will also be covered under this new code, and he can also file a claim if something is not paid to him by the company. So all the employees are covered. But I would like to tell all the participants that in the state of Haryana, this limit was deleted 3 years back in the year 2017, and in state of Haryana now also there is no limit, and every employee who is working in state of Haryana is covered under Payment of Wages Act, and he can also file a claim for claiming the unpaid amount. Next is if in case of cessation of employment, like in case of termination, discharge, dismissal, retrenchment, resignation, or death, the wages which is unpaid to an employee has to be paid within 2 working days. The wages now should not be paid in cash and should be paid through bank transfer or a check only. Next chapter is regarding payment of bonus. Payment of bonus has to be made within 8 months of the closing year. That is closing financial year. That is 31st March every year. So the payment has to be paid within 8 months. That means till November you have to pay the bonus. Then the limit, which is now 8 months, can be extended for 2 years. This thing was not before in the Payment of Bonus Act, and for that the employer has to file an application to the appropriate government. In case of state, to the state government. In case of central, to the central government, and with sufficient grounds and reasons. And only after the government permit, then this limit can be extended from 8 months to 2 years. The minimum bonus is still 8.33%, and the wage ceiling limit is still 21,000 per month. And this 21,000 per month is the gross wages. And now the definition of wages, this 21,000 will be basic pay, DA, and retaining allowance. The payment of bonus can be disqualified of any employee in case of proven misconduct through a proper and fair domestic inquiry with regard to this sexual harassment. With this sexual harassment was not there in the Payment of Bonus Act before. Fraud, dishonesty, disorderly behavior, theft, and misappropriation was there before also. Now, chapter 5 is regarding the constitution of advisory board by the central government and state government. The central government and state government will constitute a central advisory board and the state advisory board respectively, in which the representation will be of employers, employees, independent persons, and 5 from the state government, and the total team of this board will be 1/3 of ladies. This was not there before. The duties of central and state advisory board will be to advise the government on fixation on and revision of minimum wage and employment of lady employees mainly. Next chapter is regarding the payment of dues, claims and audit. In this regard, the government will appoint one or more authorities as under this code for the claims regarding wages, bonus, equal remuneration and minimum wage. In the state of Haryana, the appropriate authority is the Assistant Labour Commissioner regarding bonus, minimum wage and wages, and also for equal remuneration. Next chapter is regarding the appointment of inspector cum facilitator. This facilitator word was not there before, and now the inspectors will facilitate the employers and employees both for the compliance of this new statute and also regarding the implementation of these 4 new codes. The inspection will be done through web portal, which will be prepared and decided by the state and central government, which is also being done in the state of Haryana also. All the inspections are being conducted through this web portal, which the Labour Commissioner is the authority under this. Next chapter is regarding offenses and penalties. It is in the chapter 8 and 9. The fine has been increased quite a bit by the government in this new code, and with the fine, which was only from rupees 100 to rupees 7,500 before in the 4 statute, has been now increased from rupees 50,000 for the regular offense, and if the similar offense is repeated within 5 years, then the fine is increased to rupees 1 lakh. Imprisonment has also been increased from 3 months to 6 months in this new code. So that's all on the code of wages I had to say and discuss. And now I will be requesting Mr. Sandeep, my colleague, which I know him from last 10 to 12 years. He will be throwing some light on code on social security 2020. First, I would like to introduce Mr. Sandeep Hooda, who is a senior human resources professional. He is a graduate in law with specialization in labor laws and postgraduate in HRM. Mr. Sandeep has a career track record of 24 years in human resources and industrial relations of good Indian corporate as well as MNCs such as Escorts Class, Honda Motors in India, Skoda Auto Volkswagen India, Class in India, and Suzuki Motor in India. His main expertise lies in change management, organization planning, OD intervention, employee development through strategic initiatives, employee engagement, labor, employment and corporate laws, legal compliances, and industrial relations. Throughout his career, he has successfully managed talent selection practices, process improvements, and has efficiently managed the teams to make a significant contribution to the organization. He was also a member of Class Global HR team comprising of business units of Germany, USA, China, Russia, Hungary, India, and business unit sales and service. So now I will request Mr. Hooda to come and throw some light and discuss the new code on social security 2020. Thank you, all of you. Have a very good day. It was very nice being a part of this webinar. Thank you.
Thank you, Toofan, for such a nice introduction. I will request Toofan separately to introduce same way to my wife also. Okay. Good evening, ladies and gentlemen. So I'll be taking up, I'm taking up the code on social security 2020. What is this code on 2020? If you know, there were a lot many legislations, lot many acts which were dealing in social security. Now all these acts are subsumed together, And these acts were around, these acts, there are 9 acts which are subsumed together and are now they are called the Code on Social Security 2020. That so subsumed are the Employee Compensation Act 1923, Employee State Insurance Act, the Employee Provident Fund and Miscellaneous Provision Act, Employment Exchange, Maternity Benefit, Payment of Gratuity, Cine Workers, the Building and the Other Construction Worker Welfare Cess Act, Unorganized Workers Social Security Act 2008. If you'll see the Code of Social Security, there are 14 chapters and 7 schedules. So going further, so I'll be discussing with you all these 14 chapters, but not all the 14 chapters. Some chapters would not be there where there are no changes. So we'll be discussing only the chapters wherein there is a change in the code. So we start with the code with chapter 1, which talks about the applicability of the act. So as far as applicability of the act is concerned, there is no change as far as number of employees are concerned. So it, in case of Provident Fund, Employee State, Maternity and Gratuity. But yes, in case of Employee State Insurance Act, if you see, there is one change wherein it says that establishment working in hazardous sector would be mandatorily be linked to ESIC, even if there is only one worker working in it. So this is a major change. Even if the one worker, एक आदमी एक worker भी अगर काम कर रहा है तो उसमें भी आपको ESIC में आपकी unit को आपको you'll have to consider it, you'll have to register it under the Employee State Insurance Act. Going ahead, chapter 1 deals with the preliminary applicability and definitions. So you will find a lot of definitions which are changed in the act. So I'll be discussing all these definitions. Some of the definitions are already discussed by Mr. Saroha and taken up by Mr. Toofan also. Like the definition of wages, again there is a change in the definition of wages. But definition of wages, if you see, it is same across all the codes. Be it Industry Relation Code, be it Code on Wages, be it Code on Social Security, be it Code on Occupational Health and Safety. So in all the 4 codes, definition is same. Maybe this is already discussed, so I'll not talk about this definition again, but here I would like to emphasize that what is the impact of this definition on ESI PF. So it will have impact on ESI, impact on PF, impact on bonus act, impact on overtime calculation and impact on gratuity. Because now wages is not only basic DA and retaining allowance. So whatever is paid specifically from A to I, if that is added and if the total remuneration is more than 50%, so that amount is added to the wages. So it will have impact on EPF, ESI, bonus, OT and gratuity. In bonus, it may have some effect wherein the limit is 7,000 or minimum wages for the applicability of bonus. Maybe some of the employees, they will be out of the bonus act. And on EPF, ESI, definitely you'll have to shed more money because it is not only basic DA and retaining allowance, it is other components also which are given over here in the definition. If these components exceeds 1/2 of the amount, then whatever the amount it is exceeding, that will be added in the wages. And same is in the case of overtime calculation. So that will also be higher. Then we go on to the next definition of gig workers. This new category of workers has been included in this code. Now we are saying India is moving towards gig economy. What is gig economy? If you see now, the food is available. People, they are there to deliver food at home. Zomato, through Swiggy. So there are some workers, they are working and they are delivering those items at your home. You can order from any of the restaurants, and Swiggy and Zomato, they take it from there and deliver it to you. all these workers, Amazon boys, workers working with Amazon, delivery boys, Swiggy, Ola, all these workers come in the category of gig workers. So basically these workers, they are outside of the traditional employer and employee relationship. That is the catch, because they don't have employer-employee relationship. So they don't have any relationship. So that's why they were not earlier covered by the act. So now in the code, specifically these kind of workers being taken care by Social Security. And like there are a lot of freelance workers, they are also being taken care by the Social Security code. Apart from that, gig workers, similar kind of workers are platform workers. There is a very minimum difference in between gig workers and platform workers. So platform worker means a person engaged in or undertaking platform work, means a form of employment in which organization or individual use an online platform. This is what is happening. And in COVID times, it has increased manifold. So you can see people who are working in Urban Clap, Amazon delivery boys, all these guys, they will come under the category of platform workers. Then the third category is unorganized workers. These include home-based workers, self-employed workers. Home-based, like in BD manufacturing, the people, they work at home and they make BDs at home. So they come under the category of home-based workers. So there is, as far as I told you, that there is no major difference in gig workers and platform workers. This is the first time in India that the application-based assignment performed by many workers being recognized as employee-employer relationship. So going further, the next definition is contract labor. So as far as original definition of contract labor is concerned, there is no change, it remains same. But now it includes interstate migrant workmen also, and it does not include an employee who is regularly employed by the contractor for any activity of his establishment, and his employment is gone by mutual accepted standards of the condition of employment, including engagement on permanent basis, and gets periodical increments in the pay, like social security coverage and other welfare benefits accordance with the law for the time being in force in such employment. So those employees will not be covered under contract. They will not be called as contractor labor. So they will be employee of the contractor. So, second change is now the contractor includes subcontractor as well. Earlier in organization, what was happening, the contract was given to one contractor and he was giving it to subcontractor, and some contractor was giving it to another contractor. So there were so many contractors, but only one contractor was recognized. But now even the subcontractor is also there in the code. Next definition talks about employee. What does employee mean? Employee in the code on Social Security means everybody who is working in the company, he be doing semi-skilled, unskilled, manual, operational, supervisory, managerial, administrative, technical, clerical, or any kind of work, but other than apprentice, engaged under Apprenticeship Act 1961. All the employees who are working inside the company directly or indirectly will come under the definition of employee. Provided that for the purpose of PF and ESI, specifically here, employee shall mean such employee drawing wages less than or equal to the wage ceiling notified by the central government. So current ceiling for ESI is 21,000 and for PF it is 15,000. So this is very important. So the definition, it says for the purpose of PF ESI, it shall mean such employee drawing wages less than the or equal to the wages ceiling notified by the central government. Further, it says the purpose of, for the purpose of counting of employees for the coverage of an establishment under Chapter 3 PF and under Chapter 4 of ESI, as the case may be, the employees whose wages are more than the wage ceiling so notified by the central government shall also be taken in the account. What does this mean? As I told you, the wage ceiling for ESI is 21,000 and PF is 15,000. Suppose we take example of PF, and suppose there are 3 employees who are getting less than 15,000, and there are 20 employees who are getting more than 15,000. So will that organization will be covered under PF or not? According to this provision, it will be covered under the Provident Fund Act, because the wage ceiling which is mentioned over here will not be considered. It is total number of employees who are there. If they are more than 20, it will be covered under Provident Fund Act. We go further, that for the purpose of Chapter 7, that is employee compensation, the term employee shall mean only such persons as specified in the second schedule, and such other persons or class of persons as the central government, as the case may be, the state government may add to the said schedule by notification for the purpose of the government. So this schedule was earlier also there in the Employee Compensation Act. So now in Chapter 7 of employee compensation, again the schedule is there, but with few changes. So now there are more employees who are covered under the chapter of Social Security, or Code on the Social Security. It's a big schedule, so we are not reproducing it over here. So you can take a reference of the schedule. In the 7th chapter of the code, employee compensation, in the 2nd schedule of the code, employees employed as sales promotion employees also now covered under employee compensation, right? And secondly, shop and establishments are not subsumed in any of the act, because shop and establishment is a state subject. Every state government is having shop and establishment act. So these shop and establishment act, in my opinion, will continue to be retained as it is a state act, and in future I think there is no plan also to subsume it in any of the codes, because it is a state subject. Going further with the definition of employer as per the Code on Social Security, it says employer means for a factory the occupier of the factory, not the manager of the, not the factory manager. In a factory, the occupier of the factory is the employer. Earlier it was factory manager also. In relation to mine, the owner of the mine, agent or the manager. And in any other establishment, the person who or the authority has ultimate control over the affairs of the establishment. And where the said affairs are entrusted to a manager or managing director, such manager or managing director will be the employer under the code. Next thing what they have added is contractor. So now the contractor is also employer. Earlier contractor was not employer. So contractor was playing very safe. But now as per the code, contractor is also the employer, and he will be responsible for his activities and for his people. And the next very important thing is the legal representative of a deceased employer will be also an employer. If suppose employer dies, don't worry, his legal representative will be called as an employer. And whatever, if some dues are there, so he'll be responsible to pay those dues to the government and to the employee. Next definition is the definition of aggregator. That means a digital intermediary or a marketplace for a buyer or user of services to connect with seller or the service provider like Zomato, Swiggy, Ola, Amazon. This we already discussed, like ours is now becoming a gig economy. So not many big players are there which are there in the market, like Amazon is there, Zomato, Swiggy, all these people, they are there. As per section 114(2) stipulates that a scheme be formulated to provide the role of aggregator. So the role, because since it is new, so government will formulate a policy for the scheme wherein they will define the role of the aggregator. Up till now, they have not made a scheme. According to section 114(3), any scheme formulated may be funded wholly by center, partially by the center, or partially by the state or by the center. State and the aggregator, or wholly by the aggregator. So whatever these aggregators are, the scheme which is made, it will be funded by these people, these organizations like center. And further, section 114(4) stipulates that contribution to be paid by the aggregator should be between 1 to 2% as notified of the annual turnover of the aggregator. This is very important. If you see the annual turnover of Amazon, it would be huge. So you can see how much money will go in the fund, 1 or 2%, and it can go up to 5%, not exceeding 5%. And this fund definitely would be used for the social security of the workers working with these aggregators. And there is no reason, there is no reference of the term of the aggregator in the Industrial Relation Code, which was discussed earlier. Next definition is building or other construction work. Basically, building or other construction work does not include building and other construction work employing less than 10 workers. If you are employing less than 10 workers, then it will not come under the definition of building or other construction work. And if it is related to own residential purpose, you are making a house for yourself for residential purpose, and the total cost of such work is less than 50 lakhs, then that will also not attract this definition. It will not come under this definition. But if it is more than that, then definitely it will come under this definition. The next definition, which is very important, is interstate migrant workers. What it is, and there is a major change in the definition, which is going to impact all the establishment and the factories. How it is going to impact? Earlier, what was happening? The definition of interstate migrant workmen, there was an act called Interstate Migrant Workmen Act. And according to that act, if you are getting workers from Bihar, you are required to register in Bihar, and you are bringing those workers to Haryana, then you'll have to take registration in Haryana. And the workers who are employed through this process were under the umbrella of this definition of interstate migrant workmen. But now during a pandemic, during Corona, what happened, that people, they started going, and the government was not knowing how many people they are going to their home state, because there was no data available with the government. And it became a big news, and it was a problem for the government also. So to come out of this problem, so government has come out with a solution wherein they are saying anybody who is working from any other state in your state would be called as interstate migrant workmen. And the definition covers workers drawing wages not exceeding 18,000 per month, or such higher amount as may be notified by the central government. Suppose somebody is working in Haryana from Bihar from last 10 years, so that person will come under the definition of interstate migrant workmen. Some workmen working from Noida in Delhi, or from Noida in Haryana, in Gurgaon, will come under the definition of interstate migrant workmen. Then for the registration and all, it will all happen electronically. And there is again change in the definition of, you'll be very relieved to see now inspectors are called inspectors cum facilitators. So when inspectors will come to you, they are not only coming for inspection, they are coming to facilitate you. So this is what the definition says. So inspector work is not only to inspect and find out the problems, their job is to facilitate the implementation of the law. So this is again a major change in the thinking, and let us see how much it is translated actually. Chapter 3 on the Code on Social Security deals with Employee Provident Fund. Again, there are major changes in Employee Provident Fund. One change is there is an option to join EPFO if you're having less than 20 workers. But yes, this option was available earlier also, but was not well known. It was not advertised. And the second thing is scheme would be formulated for bringing workers coming under the category of self-employed or falling under any other category under the ages of EPFO. Now you'll see government is trying to give social security benefit to all the workmen who are working anywhere, be they are self-employed also. This is a really very good thinking of the government. And earlier it was available for organized sector. Now it is available for unorganized sector, gig workers, platform workers, and for self-employed employees also. There is a major change in the contribution amount. As per the new code, it says the contribution would be reduced from 12% to 10%. But here I would like to read the complete para for you, because this is very important to understand, because it will have a lot of impact on everyone, be it employee, be it employer. Section 16 states that the contribution paid by the employer to the fund shall be 10% of the wages for the time being payable to each of the employees, and the employee's contribution shall be equal to the contribution payable by the employer in respect of him, and may, if any employee so desire, this is very important, if any employee so desire, be an amount exceeding 10% of the wages, subject to the condition that the employer shall not be under any obligation to pay any contribution over and above his contribution payable under the code. What does it mean? First, it is clear that the contribution is going down from 12% to 10%. But if the employee desire and employer also agrees, then it can remain 12% also. And the similar situation you must have seen in the COVID. In COVID, there was a change. There was a circular from Employee Provident Fund office wherein the contribution was reduced. But many employers, they continued paying 12% and they did not reduce. Why? What is the reason? Why when they were having option of saving money, why it was not reduced? There was a reason that now in most of the companies, salaries are paid based on cost to companies, CTC. It is fixed. If you reduce 2%, then you will have to pay it somewhere else. Instead of paying somewhere else, now the employers decided, let us not change it, and paying more amount in social security in provident fund, it is always better, because you earn more interest rates, 1 or 2% more than the market. So in my opinion, it will not have any impact at all, although it depends on the employer. So it's only my opinion. So maybe if there is no clarity on, if there is any clarity given by the government, then it will get clarified, or by Provident Fund Department. Last time they had FAQs, maybe this time also they'll have some FAQs wherein we'll get more clarity on this. Or in I have seen there are some conflicting provisions also. In one act it says something else, in another act, another code, sorry, it says something else. So maybe with the time, with the judicial, this will be tested by judicial process, and finally if there is some ambiguity, so it will get clarified in the times to come. There is no other way out. So that is the only way out, or the government will change the code according to, if they feel that if something is wrong is mentioned. We go to chapter 3 of Employee Provident Fund. It talks about the code empowers the central government by order to defer or reduce employer contribution and employee contribution, or both, payable for a period up to 3 months at the time in the event of pandemic, endemic, and national disaster. Again, this is government is motivated by whatever happened during the COVID times. During next point is, during insolvency proceedings, any amount due to EPFO by an employer, it shall be treated as a charge on the assets of the establishment to which it relates, and shall be paid to priority in accordance with the provisions of the insolvency. Sorry, just a minute. During insolvency proceedings, any amount or EPFO by an employer, it shall be treated as charge on the assets of the establishment to which it relates, and shall be paid in priority in accordance with the provisions of the Insolvency and Bankruptcy Code 2016. Priority to payment of contribution would be over debts. Then next is pre-deposit for appeal against EPF assessment. The code provides for appeal against an order passed by any authority in regard to determination and assessment of the dues and levy or damages relating to employee provident fund by an employer only after depositing the social security organization concerned. That is, in case of appeals, 25% amount you'll have to deposit. This provision was there earlier also. So now the next point is penalties. So if you see the penalty amount is increased from 10,000 to 1 lakh rupees and imprisonment of 1 to 3 years on the deduction of employee contribution from salary. And if you are not depositing, you are deducting the amount, but you are not depositing the amount. So that will attract the penalty of amount ranging from 10,000 to 1 lakh rupees. And subsequently, if you are doing it, then it will go from 2 to 5 years, imprisonment of 2 to 5 years, and fined up to 3 lakh rupees. Then when we go to employee state insurance cooperation, the applicability of the act remains same. There is no change. Gig workers and organized sector and plantation workers are also brought under the preview of ESI. And the next is employer and the majority employees agree, then the voluntary registration has been allowed under this code. So it is same as under Provident Fund Code. So voluntary registration is allowed under this code also. Implemented area, the facility I say would be available in all the 740 districts. This is very important. So government is planning to give this benefit in all the districts. Benefits even when contribution are not paid. This is very important provision. If you see what was happening earlier, the employer was not paying contribution, and when employee was going to ESI, if you take the benefits were denied by ESI, saying that your contribution we have not received the contribution from your employer. But now the code says if the contribution is not received by ESI, then also ESI will give the benefit to the employee, and then whatever benefit they have given to the employee, they will charge back from the employer along with interest and damages. So the people in the audience, the guys who are taking care of ESI, PF, wage and salary administration, please be careful to deposit all the amount on time. Otherwise, you'll have to pay huge damages, penalties, and it can go to imprisonment also. Establishment working in hazardous sector would mandatorily be linked with ESIC, even if there is only one worker working on it. This I have already discussed. Next point is the code empowers the central government to frame schemes for unorganized workers, gig workers, platform workers, and the members of their families for providing benefit relating to ESIC. And the code empowers the central government by order to defer or to reduce employee contribution or employee contribution or both payable for a period up to 3 months at the time of in the event of pandemic, endemic, or national disaster. So basically here, if you see, the government is motivated by what happened during COVID, and at that time also it was deferred. So this has now is reflected in the code as well. So if it happens in the future, so government will have a power to defer it. And the next point is related to insolvency proceedings. The amount due to ESIC by an employee shall be treated as a charge on the assets of the establishment to which it relates and shall be paid on priority in accordance with the provisions of the insolvency and the bankruptcy code 2016. That means there will be a priority of payment of contribution under this code rather than other debts. So employees, because it's a social security code, so it will have a priority over the other debts. Now I go to chapter 5 of the Code of Social Security. That is, chapter 5 deals with gratuity. The provisions of gratuity has been kept unaltered. There is no change from the present Gratuity Act, whether it is with respect to applicability, eligibility, except for fixed term employee. Basically, in case of a fixed term employee, gratuity will be paid to employee who has done minimum service of 1 year, and it will be paid on the pro rata basis. What does it mean? Suppose somebody has done a service for 1 year, 2 months, so he'll be paid gratuity for 1 year, 2 months on pro rata basis. Suppose somebody has done service for less than 1 year, then he will not be paid gratuity at all. And in case of working journalist, the period of 5 years is reduced to 3 years. So these are two changes. And apart from that, other employees will get gratuity as usual after completion of 5 years, that is 4 years, 240 days. It is noted that as per section 53(2) of the code, gratuity will be calculated as per new definition of wages, and therefore the cost will go up. Definitely, you'll have to budget it like that. So gratuity is going to cost you more, guys. This amount of gratuity will go up. Why it will go up? Because there is change in the definition of wage. So right now gratuity is paid on basic DA and retainership allowance, but in future the gratuity would be payable on these three components, which is wages, and on other components which were mentioned from A to I. And if it is going beyond 50%, that would be added in the wages. So definitely it will have impact on gratuity. So it's a good news to employees, but employers, they have to shed more money. Next, chapter 6 of Social Security Code deals with the maternity benefit. So basically, if you talk about maternity benefit, there was some confusion in the creche facility. As per the Maternity Benefit Act, it's earlier it was saying that wherein 50 employees are employed, the creche facility would be applicable, and in the Factories Act, it was 30 women workers. Later on, it was changed. So, and now in this code, again, there is ambiguity. If you'll see, every establishment to which this chapter applies, in which 50 employees or such number of employees as may be prescribed by the central government are employed. So basically, as per as per chapter 6 of maternity benefit, creche facility defines it that wherein 50 employees are working, creche is to be provided. But as per Occupational Health and Safety Code, it says wherein 50 workmen are working, you'll have to provide it. So there is ambiguity. So it is not clear. So, but yeah, it is, again, with the time it will be clear. And in our opinion, we should give benefit of doubt to the employees. So employees should be considered, 50 employees should be considered instead of 50 workmen in the company to provide creche facility. But if you see the definition of creche, what is creche facility is now totally changed. Earlier, companies were required to maintain creche facility in the company, and it was responsibility of the company to provide creche facility. But now there is a provision under the code that you can set up this creche facility with the group of establishment. Some private players can establish it, hospitals can establish it, central government can establish it, state government can establish it, and it need not to be there in your establishment. So you can use the facility. So this is another change wherein you need not to maintain it, but you should have a creche facility. You should have a tie-up with the person who is providing this facility, which is a big relief, I suppose, to all the employers, because now the number is also changed. It is now 50. It is applicable to 50 employees. So next definition is the term work of arduous nature has been explained for the first time in the code. The expression any work of arduous nature, this is again related to women employees. It says it shall mean any work which involve or requires strenuous effort or is difficult and tiring in nature. अगर इस तरह का काम है तो वो इस एक्सप्रेशन में आएगा. तो ये भी इसमें इस बार डिफाइन कर दिया गया है एक्ट के अंदर. So now I go on to next chapter, chapter 7, employee compensation. Report of fatal accident and serious bodily injuries. Nothing in this section shall apply to establishment to which chapter 4 ESIC applies. So chapter 7 deals with employee compensation. If some establishment is already covered under ESIC, then this chapter will not apply to that establishment. It clearly says that. Earlier also it was there in the act. In earlier act, it was also limited to factories, but now the court specify that it applies to establishment as well as establishment. As you remember, I told you now gig workers are also under social security, platform workers, unorganized sector is also taken in the social security. So the umbrella is big. So under this umbrella, so now the establishments are also, they also come under the it applies to establishments as well. Next is code clearly specifies that the compensation is payable even when the employee is going to work or returning from home from work. This is very important. Earlier, there were a lot of decided cases. Before I tell you about this, I would like to share one thing. I have seen in all the courts, there are a lot of definition, there are a lot of changes which has happened, which were not there in the act. But they were already adopted by some of the states through their legislation, through their notification, or it was through judicial process. It was declared by Supreme Court. When once something is declared in the Supreme Court, then it becomes a law. So there were lot many cases wherein it was decided by the Supreme Court and everybody was following it, but it was not amended in the act. Now all those changes also amended in the codes, all the 4 codes. So this is one wherein it clearly says, specify that compensation is payable even when an employee is going to work or returning from home. So earlier it was paid based on the decided cases, but now it is specified in the code. It is more clear to everyone, and all the employees can now, if something happens, they can take the benefit. The court specified that once an agreement has been arrived at between the employee and the employer, the payment of compensation, it will, for the payment of compensation, it will disentitle employee for instituting any civil suit for the same. Earlier, what was happening? People, they were taking compensation and then they were filing a suit. So now in the code, it clearly specifies once it is settled, then you cannot file a civil suit. So that makes life very easy. Otherwise, employer keep on running from pillar to post, from one court to another court. And you know, in India, like court takes a lot of time to decide the case, even if it is of no value, or if it is wrong, it is wrong also. And then the next change in the act is the amount payable for funeral expenses has been increased from INR 5,000 to 15,000. Earlier it was 5,000, now it is 15,000. In early act, where an employer is in default in paying the compensation due within 1 month from the date it fell due, in addition to arrears, had to pay simple interest at the rate of 12% on the amount due. Now the court states that the rate of interest will be as prescribed by the central government. We continue with the chapter 7, employee compensation. The sum payable as compensation specified in section 61 has been increased and not less than rupees 5,000. Earlier it was not less than rupees 10. So from 10 it is increased to 5,000. And there is a provision in case of this provision is added in case of medical examination, in case of accident. If medical examination is required, then the medical officer, medical practitioner will have a right. So those things are mentioned over here. Next is it has been added that the contractor shall be liable to indemnify the employer with respect to compensation under this law. So the contractor cannot run away. He'll have to indemnify the employer. The next point states that the competent authority may provide an advocate from the panel of advocates maintained by the state government to the dependent of the deceased employee who is not in the position to engage an advocate to file a claim for the compensation. The next chapter is chapter 11, authorities, assessment, compliance and recovery. There is a change in case of a limitation period. Limitation period for inquiry and determination for dues in the matter of contribution of ESNI and PF. There is change. It's a big relief to all the employers and all the employees who are involved in wage and salary administration, because now it says that the inquiries limitation is of 5 years. Earlier, what was happening, whenever the inspectors they were going for the inquiry, when they were going for the inquiry, so what was happening, they were checking a lot of things. They were going in detail, and they were checking like maybe they were going for 10 years, 15 years, they were checking the accounts. But now the code restricts it up to 5 years only. Under this chapter is the outline of procedure, namely ESI, PF having web-based inspections. This Mr. Kohad already explained that now these web-based inspection, the selection of inspection would be on random basis, factories will be considered, and unique number of establishment would be given. In addition to that, the inspector is now called inspector cum facilitator in all the courts. This we already discussed. Employee may file returns electronically, issue wage slips. This is quite happening right now also, but in future, after the implementation of the code, maybe in all the returns will be filed electronically. Time limit is also prescribed for the completion of all the inquiries. The next is chapter 12, offenses and penalties. The fines have been increased by up to 10 times. So everybody will have to be very careful. The fines are very much high nowadays, and as compared to previous acts, now amounting to rupees 50,000 to 1 lakh rupees. Subsequent offences fine has been increased to INR 2 lakh, provided that where such second and subsequent offence is for failure by the employer to pay any contribution, charges, cess, maternity benefit, gratuity, compensation under this code, he is liable to pay for such second or subsequent offences, be punishable with imprisonment for a term which may extend to 3 years, but which shall not be less than 2 years, and shall also be liable to be fined of 3 lakh rupees. So now here all the guys managing wages and salaries will have to be very careful while dealing with ESI, PF and depositing ESI, PF on time. Now I go to the next chapter, that is chapter 13, which deals with employment, information and monitoring. The code may make it mandatory for all establishments with certain number of workers or more to compulsory report vacancies. This was already there, but now they have introduced there'll be online portal which will be called career portal, wherein you'll have to put in all the vacancies. And in chapter 9, miscellaneous, Aadhaar card is mandatory. As you are aware, in some of the transactions earlier, and Provident Fund Aadhaar was already mandatory, but now it is mentioned in the code. And as per the section 145, it has been enacted that in case of transfer of establishment, this is very important, the employer and the person to whom the establishment is transferred shall jointly and severally be liable for payment of the cess or other amounts under the law. However, the liability of transferee will be limited to assets obtained by him in the transfer. So the person who has transferred cannot say that I have transferred, I am not, no, I am no more responsible for the dues. Right, gentlemen. So I am over. I have completed the code on social security with this. Now the next code, the Occupational Safety, Health and Working Conditions Code 2020 will be taken by Mr. Malik. I would like to introduce him. Mr. Malik is senior HR professional, a graduate in law with specialization in labor laws and postgraduate in HRM. Mr. Malik has a career track record of 30 years in human resources and industrial relations of good Indian corporates as well as MNCs such as Ambuja Cement, ITC, Godfrey Phillips, FCC, Baxter India. Exceptionally successful in managing end-to-end HR and IR processes at different levels in a metric structure and ensuring risk and compliance for the business to realize the bottom line results and realigning policies to drive change across the organization in pursuit of objectives to create an amicable and transparent environment. His expertise lies in industry relations, labor and employment laws, and legal compliances. So I would, with this, I would request Mr. Malik to throw some light on the Occupational Safety and Health and Working Condition Code 2020.
Thank you, Sandeep. Sandeep has been enjoying his explanation about the Social Security Code in detail, and I believe he has made his concept clear to all of us that what are the basic changes that have taken place into the code. As you know, all these 29 acts have been subsumed into 4 codes. Similarly, the Occupational Safety, Health and Working Condition Code also subsumed 13 acts, which has been taken into consideration for jointly responsible for all these safety, health and working condition into the establishments or factories. Those are namely the Factories Act, the Plantation Act, Mines Act, Working Journalist and Newspaper Employee Conditions, Working Journalist, the Motor Transport, the BD and Cigar Workers, the Contract Labor Regulation Abolition Act, the Sales Promotion Employees, the Interstate Migrant Worker, the Cine Workers, Dock Workers, Safety, Building and other construction workers. Now come to the preliminary part of it and the definition part of it. The appropriate government, as has already been explained by Saroha, that holding of PSUs, even if the holding becomes less than 50%, even then the appropriate government will be central government. And same goes in the state governments also. The definition of wages has already been explained across, it is similar across all the 4 codes. Now, when you look at the codes, in the acts at various places, the definitions of work ban or the wages were explained in different ways, though the meaning was similar, but the words were different. Here, the definition of wages has been dittoed in all the 4 codes. Workers, those employees, those who are engaged into skilled, unskilled, semi-skilled category, also includes supervisory capacity getting salary less than 18,000 rupees. It also includes the sales promotions employee. Those are working for sales, but the condition here is again is that drawing salary less than 18,000. Building and other constructions worker has now increased the limit of eligibility, whereby building, construction worker or residential purpose of individual or group of individual for the use for their own use, but the amount spent so in construction of the building is less than 50 lakhs will not be covered under building and other construction work. Contract labor, who is employed in connections of work of establishment hired by contractor with or without the knowledge of principal employer, and includes interstate migrant worker. Contractor is a person who supplies the manpower to carry out the work of an establishment and includes subcontractor, machinery. It is combination of article or combination of article used to intended to be used for converting any form of energy to perform work into perform the work. Employee is respect of establishment, a person other than apprenticeship who is engaged to do skilled, semi-skilled, unskilled, manual, operational, supervisory, managerial, administrative, technical, clerical work or hire or reward. Now here in all these codes you will find, since these codes have been subsumed by taking few acts into one code, here you will find that the definition you will find the word establishment or employees being used more frequently than the worker or the factory which we are used to. Similarly, sales promotions imply those who are drawing salary less than 18,000, but it excludes those who are employed in managerial and administrative capacity. The factory, the section 2W, the threshold limit from 10 to 20 has been increased with use of power and 40 without the use of power. Employer, occupier is employer in the factory. In case of mines, it is manager or mining agent. In case of establishment, it is manager or managing director. Go down. The word go down has first time been used because the go down is where the frequent movement goes for material inside the storage of the material, maybe which is used in the process of manufacturing, or even otherwise the working condition therein go down has to be taken into consideration. Similarly, core activity has been defined. Any activity for which the establishment is set up includes activity which is essential. It clearly segregates the core activities and other activities. The other activities which are not core are segregated, say like sanitation, security, canteen, loading, unloading, courier, transportation, service, ambulance service, and other activities of intermittent nature. We have always been under confusion while discussing the perennial nature of job and the activities which are being carried out into the organization, whether the activity are of perennial nature or not. So that has been clearly segregated, that the core activity has been totally segregated from the other activities which are not required, which are not attached with the essential activity for which the establishment is set up. Interstate migrant workers means a person who is employed in an establishment has been recruited directly by the employer, indirectly through contractor in one state for the employment in such state in another state, has on his own from one state and obtain employment in the other state. Now chapter 2 deals with registration. After the commencement of the code, every establishment has to apply for registration within 60 days electronically and to the registering authority, and it shall be deemed to be registered if the information about the registration is not received within 30 days. Cessation of operation. Similarly, when any establishment is to be closed down, the way it has been informed while registering the cessation of operation or closing down of an establishment has to be informed to the registering authority. In this section, there are appeals which lies to the registering officer authority and thereafter for any litigation. Duties of employer and employee. Now, employer has to provide safe working conditions in the facility by ensuring that plant and machinery is so designed that it does not make unsafe place for employees working there. Comply with occupational safety and health prescribed under the code. Annual health examination as prescribed by the appropriate government at such age as required, and in dangerous operations or hazardous operation, it has to the medical examination free of cost has to be carried out before employing a person into that activity, into that process. That every employer has to issue the appointment letter to employee so prescribed by the appropriate government. Duties of designer, manufacturer, importer and supply is defined in the code. That every manufacturer, importers has to supply the machines or the machinery which is safe for working into the company or establishments. That certificate is required, that manufacturing and importer supplies, even the importers has to give a certificate for the safety and the provisions of this. Duties of architect, project and engineer and designer is defined in the code. For building and other construction activities, the architect, project engineer and designer has to give in detail the procedure plans so that the life of the workers is not at stake while working in the building and other construction activities. Duty of employees. That every employee takes reasonable care of his health and safety and comply and cooperate with employer in meeting out statutory obligation under the code. National Occupation Safety and Health Advisory Board to frame standard rules regulation under the code. Similarly, every state has to formulate state advisory board and frame rules and regulation required to be executed in various establishments in the state. Safety committee. Every establishment has to have where 1,000 employees were employed, a safety committee was to be formed with equal representation of employer and employee. Here in this case, the factories wherein 500 or more employees are working, a safety committee is must, and in case of hazardous process where 250 workers are employed, it is must. In case of building and other cases, it is 250, it is mandatory, and 100 where 100 workers are working in case of mines. And it is the duty of appropriate government to appoint as many safety officers as framed or as decided by the appropriate government or state governments under the rules. Health, safety and working conditions. The chapter provides responsibility of employer for maintaining health and working condition in the establishment, and central government as well as state government may make rule for such purpose. It mainly covers safety provisions under the various acts, such as safety provisions under the Factories Act from section 20 to 40 are now mentioned in second schedule. Now, since the safety provisions covered under the Factories Act alone are not the safety measures to be taken into consideration, since this subsumes 13 Act. So all the safety precautions or safety provisions required to be followed in various establishments, mines, plantation, those have been taken in the second schedule in detail. Welfare provision. Now, for the first time, the transgender has been used as a separate washroom, restroom, washing facility, storage, drying, locker room, all those to be provided for all the three genders. A canteen facility which was earlier for 250 employees now has been reduced to 100 employees, which includes the contractual worker as well. The appointment of welfare officer in factory, mines, plantation, where 250 workers are working, earlier it was for 500 under the Factories Act, or more ordinary employed in qualification, the qualification and condition of service duties of such welfare officer as decided by the appropriate government under the rules. Hours of work and annual leave with wages. Chapter 7 deals with hours of work, which is limited to 8 hours. The period of work shall be so fixed as not to exceed such hours, which shall with intervals and spread hours as may be identified by the state government or the appropriate or central government, as the case may be. Extra wage for overtime shall be double the rate. The consent of worker is mandatory, however, will be decided by the appropriate under the rule. Now here I would like to explain my own thought process after having worked with the industry for so many years. The calculation of overtime in various industries is basically to avoid to pay more to the employees. Here the consent has been taken that the worker who wants prosperity at his home wants to work on overtime. The overtime is so designed by the rate of wages that every person, the wages on which the OT will be calculated will be paid double. Earlier the case was somebody was paying on basic wage, somebody was paying on basic NDA. Now it has been made clear, as explained by earlier speakers, on the payment of wages. Now every establishment has to maintain, register, records, notices as required and electronically file to the appropriate government the returns and records. The notice has to be displayed, which includes the working hours, shift hours, the inspector cum facilitator for that area and things like that. Inspector cum facilitator and other authorities. It defines the code renamed as inspector cum facilitator. Here the duty of inspector is not only to carry out the inspection and find some fault into the organization or establishments and issue some notices to pay some penalties, but here it has been required that the inspector cum facilitator has to sensitize the employer and workers regarding provisions of the code and compliances thereof. It is basically the support system which the government will be providing after the code. The word facilitator itself proves that it will be a helping kind of machinery thereafter. Working hours for women. The women in this code has been empowered to that extent that they can work in the night shift from 7 p.m. to 6 a.m. with their consent, adhering to the rules of holiday, safety conditions and working hours as provided by the employer. The women are empowered to work on dangerous operations with their consent and with adequate safety precautions provided by the employer. Chapter 9 has redefined inspector cum code, who is renamed as inspector cum facilitator, as explained earlier. Special provision for contract labor and interstate migrant worker and audiovisual workers. contract labor applies for establishment engaging 50 or more contract labor or contract company employing 50 or more contract labor. Here also the contractor has to provide the appointment letter to each contractor employee or worker working there with him. This will apply only to the establishment engaging 10 or more interstate migrant worker. It is provided in section the employer shall to pay lump sum amount to and fro fare for the journey to his hometown once in a year. Under the new definition, audiovisual workers, singers, newspaper readers, dancers, stunt persons, technical artists, work like supervision, etc. has been covered, subject to some wage ceiling to be notified by the central government. Building and other construction activities. Now, since the Act, building and other construction activities work has taken almost every aspect in the country, the building, streets, road, railways, trams, towers, likewise into consideration, which are covered under the building and other construction activities, except as explained earlier that for the personal use of an individual or group of individual for his own use will not be considered as building and construction activity as notified by the appropriate government. Now coming to the offences and penalties. Here I would like to throw some light on the offences and penalties which has been enhanced to the tune of, say in some of the cases it is almost more than 10 times or even more. It is solely because if we take the important part of safety provisions prevailed in various companies, the safety of human being is of utmost importance. The employer fails to comply with the compliances which are required to be followed. If you all remember, it was night of 2nd or 3rd December 1984 when in the Union Carbide case, the methyl isolate leaked out and 20,000 employees died on 2nd and 3rd night, also affecting the health of 5 lakh employees or more. The person who was responsible is scot-free in United States and he left the country without any penalized or punishment. Now, in order to comply with the safety of all in premises has been enhanced by various offences from 1 lakh to 5 lakh, and continuation of the offence in hazardous process has been revised to 20 lakhs and imprisonment of 5 years. In case of any non-compliance with result of accident, dangerous occurrence, cause of death shall be punishable with imprisonment of a term which may extend to 2 years or fine which shall not be less than 5 lakh rupees or both. Now here, the amount of penalty so lied in the case of death of an employee, the 50% of the amount has to be passed on to the family of the deceased. So here it is a very good step by the government where the poor family who loses the source of earning will be helped by this way, and the other compensation as decided by other courts into the country. The employee has also been made responsible to adhere to the safety provisions so desired to be followed. In the employee contravenes the violates the safety measures so desired will be penalized to the tune of ₹10,000 rupees. In case the employee is victimized and is proved for the violation, then the employer will not be held responsible for the same offense. Now coming to the schedules, there are 3 schedules in the Act. Number 1 deals with industry involving hazardous process, 2 deals with safety provisions, third deals with the notifiable disease. Thank you. So nice of you. Thank you.
Thank you. Thank you, Mr. Malik.
Thank you.
Well done.
Thank you.
Thanks a lot, Mr. Malik, for throwing light on social security, on occupational health and safety code. Now we have with us Mr. Saroha, Mr. Toofan, Mr. Malik. So now we'll take up the questions which we have received during the webinar. So we'll be discussing the questions which are there, although the time will not permit us to discuss all the questions. The questions which are left out, as I requested earlier also, you can write it on to us on sarohajs@gmail.com, and we'll get back to you as soon as possible. And repeating the mail ID, sarohajs@gmail.com. Just a minute, we'll just align the camera accordingly so that everybody can fit in. I think now we are able to fit in the camera. So maybe quickly I'll ask, I know you all are in a hurry to go home. So we'll take up a few questions quickly. So my first question is, I would like to ask Mr. Toofan, on what components of wages are we required to deduct PF, ESI? And there is one more question which is related to the same. And on what components OT and gratuity is payable? Maybe you can take up both the questions together.
Yeah, as per the new definition of wage in 4 codes, the wages now include the basic pay, DNS allowance, and returning allowance. But also there is a catch if the allowances which have been mentioned in from clause A to I, if the total of those A to I exceeds the 50% of total wages, then that part of wages will be treated as wages. So the deduction of PF, ESI, gratuity, and OT will be on this definition of wages.
Yeah, thank you. Here I would like to further say that basically in view of the change in the definition of wages, we need to restructure our salary and wages so that we can align well according to the new definition. Otherwise, it will be very difficult for the employer to calculate contribution for ESI, PF, OT, and basically OT, ESI, and PF. So it's better to realign and readjust, restructure the salary components.
Both the employees
of workers and employees. Yeah. Wages and salaries, both. Yeah, you're right. So my next question is to Mr. Saroha. Can we employ contract labor in production?
No, reply is to be no, because in core activities, which are the production lines, etc., no contract labor is permitted.
Okay, so it is clear from the answer of Mr. Saroha that we cannot employ contract labor in core activities.
And only permanent employees who are only permanent employees who are on the roles of the company should be employed on the core activities like production, which is a core activity in the manufacturing factories or plants.
Very true.
Yeah. I would like to further add, in the definition, it is clearly mentioned what are the core activities and what are non-core activities. You can refer to the definition also. You will. It is clearly stated the activities which are not core activities. So, thank you, Saraji and Tufanji, for this. And second, from to Saroha Saab, when these codes are going to be implemented?
No dates have been given in the code, but it is expected that the codes may be implemented by next year, April, as per the statement of the Minister of Labor, and also because state government, central government have to come out with the rules on the subject.
So it will take some time, and as per the statement of Ministry of Labor, it may come next year around March or April. No date is notified yet.
Okay, so tentatively it is 1st April. So maybe as far as restructuring of wages and other activities, you can make your checklist according to the new act. Now you know what the act says, so you can make your checklist and you can prepare yourself for the act. So now you have enough time to prepare yourself. So now I go with the next question. Is gratuity payable to fixed? This question is, I think, not clear. Yeah. So the question is gratuity payable to fixed term employee also?
Yes, as per the new code, the employee engaged on a fixed term who has completed 1 year of service will be paid gratuity.
Okay, and 1 year service and on pro rata basis, this gratuity would be paid to fixed term employee. And the next question again to Mr. Toofan is, who will maintain the reskilling fund?
This is a new concept under the IR code. The reskilling fund has to be maintained by the government, and the employees who are retrenched by the employer has to pay the government the fund, this reskilling fund, and the government has to pay this reskilling fund to the concerned retrenched workers within a period of 45 days. And this reskilling fund is equivalent to the retrenchment compensation.
Yeah, so it is 15 days as rightly it is explained. So retrenchment compensation is separate, and this is additional payment which Mr. Toofan explained. This is additional payment which will be paid, and it's a, you can say, additional burden, but it's not much. It's the amount is too less, only 15 days salary. So next question is to Mr. Saroha ji, is it compulsory to have creche in the company premises?
No, it's not compulsory. You can have joint creches by few companies together and provide the service of creche.
Okay, so now it's clarified that creche is not required. In you need not to maintain it in the company, so you can use common creche facility. The next question is again to Mr. Saroha. This question is, we have one question is like this. We have 150 workers. Somebody has written this question. Do we need to take permission of layoff from the government? So one company is having 150 workers. They are asking, do they need to take permission of layoff from the government?
No, permission is required only when 300 plus workmen are there. Since the number is less than 300, no permission is required.
The same process has to be followed in case of retrenchment and closure. In the state of Haryana, the limit is already 300. If in the past 12 months, preceding 12 months, we have employed less than 300 workers, then there is no need of permission from the government regarding layoff, retrenchment, and closure. But now central government has changed this limit to from 100 to 300.
Thank you, Suraj Saab and Panji for. And the next question is: a lot of our on-roll workers are from Rajasthan, and our unit is in Haryana. Will the workers falls in the definition of migrant workmen? So actually, what they are saying is they have unit in Haryana, but a lot of workers from Rajasthan are working in their unit. So will they come under the definition of a migrant workman? This to Mr. Toofanji.
Yeah. Yes, as per the new code, the employees or workers who are coming from a different state and working in a different state will come under the definition of migratory workers.
Right. Thank you, Toofanji. So the migrant workman is clear. The next question is: what is new concept of negotiation council? This is to Mr. Suraji.
Where there is no negotiating union having 51% of the workers' force, there has to be a council consisting of more than one union, and for that 20% of workmen of that union will representative one representative.
So, meaning thereby where there is no majority of the union, which is more than 50% of the total workers, there a negotiating council has to be made, and in that negotiating council, on every 20% of workers, one representative will be there.
In the case of multiplicity.
Yeah. In case of where there are multiple unions.
Very true.
Yeah, rightly said. So it is in the case of multiplicity of union. So you'll have to have a negotiation council, wherein one union is not having 15%. Right. Thank you for the answer. So we move on to, we are receiving a lot of questions, but I think we'll not be able to take all the questions. Maybe we can take, we've taken a lot of time of Saroha, Toofanji, Mr. Malik. Maybe we'll take, yeah, myself too. Thank you. So we'll take up 2-3 more questions, and then rest of the questions you can write it on to us at sarohajs@gmail.com. So we go on to the next question. What is the difference between working of works committee and trade union? This to Saroha.
Works committee consists of workmen and management representatives, whereas the trade union consists of the workmen only. Trade union is supposed to file general demand notice, negotiate on behalf of the workers with the management, whereas works committee is a bipartite body.
And the works committee cannot sign a settlement, tripartite settlement or bipartite settlement on behalf of the workers. That has to be signed by the workers representative or wherever there is a union, trade union.
Thank you. Next question is that they're saying that we have 700 workers and our standing orders are certified. So they have 700 workers in the company and their standing orders are certified. They're saying, do we need to rectify standing orders? Recertify standing orders?
No, as per the new code, once a certified, once a standing order has been certified, it needs not to be re-certified again by the government or from the government. So it is the standing orders are already certified. They are not need to be re-certified again.
Yeah. So it is specifically mentioned in the code. Thanks, Toofanji. So next question is to Saroha Saab, in this question is, we have 100 employees, including workers. Is crèche facility mandatory to us?
Yes, as per the new code, wherever the company has engaged 50 or more employees, crèche facility is mandatory. And in this case also, as they have engaged more than 100 workers and employees, as stated in that question, so crèche facility is mandatory for you.
Thank you. As rightly said, crèche facility is mandatory, but now as per new provision, you can use the crèche facility maintained by central government, state government, or any other private institute, hospital jointly, or you can maintain it jointly with other establishment as well. So that's good. So we are taking last question, because will not be able to take more questions. Last question we are taking for the day is, how long can we employ a fixed term employee?
Though the period has not been fixed in this code, but we feel that 2 years can be a normal good period. And for the state of Haryana, government is already certifying standing orders where fixed term employment, they are making it 2 years.
So in Haryana, it is already it's mentioned in the standing orders 2 years. Maybe you'll have to check the standing orders in your respective states. What is the, and once the new standing orders are out, model standing orders are out by the central government, then you can check that also. When the new rules are out, rules are also under, now draft rules are already out. So once the final rules are out, by the central government, and the state government will also make the rules, then only things will get clarified. There are a lot of, if I see, there are a lot of ambiguity at many points, which it is difficult to say right now, which way, how to, I mean to say, compliance of these code, how it will happen, and what is the exact definition. So maybe once those things are there, so after the rules, everything will clarified. It will be clarified. So first, I would like to thank Mr. Saroha for taking out so much time out of his busy schedule for this seminar. Mr. Toofan ji, Mr. Malik, and the most important, thank you, Mr. Malik. And most important is you all the participants. Thanks a lot. Without you, this program is futile. So thanks a lot for believing in Saroha and Associates and joining the program. And thank you very much. And it is our endeavor to provide, to do webinar and seminar on different labor acts and labor laws. And in future, we'll strive to provide you legal knowledge as and when there is a change. Thank you. Thanks for joining.
Thank you all. Thank you very much. Thank you very much.
Thank you all participants.
Thank you. Bye.